in the legal system of each state. Cases involving will disputes, elder financial abuse, and breach of fiduciary duty are initially argued in probate and chancery court. These are their stories.
Hello, I'm David Russell, editor of wealthandhonor.com, and welcome to Wealth and Honor, the Case Files, where we undertake a non-legal analysis of actual court cases involving will disputes, elder financial abuse, and estate litigation. Now, before we get started, let me remind the viewers that I am not a lawyer. My commentary should not be taken as legal advice or expert legal opinion. If you find yourself in circumstances such as what we're about to review, you should hire a lawyer licensed in your state to advise you. No, the reason for examining these cases is to learn from the mistakes of others and hopefully keep ourselves, our clients, or our loved ones out of the courtroom. Most advisors will tell you that the courtroom should be the arbiter of last resort. But we do have these public records, these stories to learn from. And so my intent is not to air another family's dirty laundry or to gloat in their misfortune, but to look for the warning signs that our own families might have in common with these. We'll look at the parties involved, the context of their lives, and the decisions that were made that may have led to conflict and litigation. Perhaps their experiences will spare your family from avoidable conflict later on. Before you watch this episode, if you've not viewed the presentation on frequently used terms in the case files, I recommend you watch it first to familiarize yourself with many of the terms used throughout the case files. As with each episode, characters identified in the court transcripts are portrayed as characters in popular TV sitcoms or dramas. I think this gives the characters depth and often adds a touch of humor to an otherwise serious legal matter. For now, I hope you enjoy this episode of Wealth and Honor, the Case Files.
Background facts. Horton represented a 74-year-old client in drafting a revocable living trust and power of attorney. Horton admitted to drafting a Fifth Amendment to the living trust naming himself as a 50% beneficiary in the distribution, dated July 19, 2011. In September 2016 and October 2016, the client agreed to loan Horton a total of $90,000. Horton used the power of attorney issued to him by the client to issue 3 checks to himself from the client's checking account in September and October 2016. On October 14, 2016, Horton wrote a 4th check to himself in the amount of $15,000 from the client's checking account and attempted to deposit the funds into his personal checking account. The client disputed this 4th loan, and the check was returned for insufficient funds because the client had closed the account. Horton admitted that he initially did not provide a promissory note to the client to secure the loan, nor did he advise the client to seek the advice of independent legal counsel regarding the transaction. In a separate matter, Horton represented a 75-year-old client. On or about August 30, 2016, pursuant to a durable power of attorney issued to him by the client, Horton transferred $30,000 of the $32,000 balance in the client's money market account to her checking account. The same day, Horton transferred $30,000 to a trust account for the client. Following the client's death on September 5, 2016, Horton transferred $17,500 of the $30,000 to his operating account by issuing a check. He noted in the memo of the check that one half of the amount was for his attorney's fees and the other half was for his work or appointment as the personal representative of the client's estate. Horton testified that he had not yet been appointed as personal representative by the probate court at the time he took this fee and that he was not appointed as personal representative of the client's estate until 2 days later. Matthew Herdiker, branch auditor of the Florida State Bar, conducted an audit of Horton's trust accounts. Herdiker testified that Horton used a portion of the $17,500 payment to cover an overdraft in his operating account, transferred part of the funds to his other business accounts and another personal account, and paid various operating expenses at his law firm. On October 19, 2016, Horton issued an additional check for $15,500 from the client's estate account to himself for fees as personal representative. This was the same day that Horton's bank had dishonored the $15,000 check he issued from the account he held pursuant to a power of attorney granted to him by the first client. Horton testified under oath during his sworn statement on April 6, 2017, that it wasn't a coincidence. I needed that money, so I thought I would take a portion of my personal representative's fee.
In a different matter, Horton represented an 85-year-old client. Pursuant to the power of attorney prepared by Horton and granted to him by the client, Horton changed the name and address on his client's accounts to reflect Horton's name and mailing address. Horton indicated that he made these changes at the request of the client in 2015. Horton issued 34 checks totaling $43,000 from the client's accounts to either Horton's personal checking account or operating accounts. In 2016, Horton issued 33 checks totaling $82,840 from the client's accounts to either his personal checking or operating accounts. During this same time period, Horton deposited funds back into the client's checking accounts totaling $40,050. After the bar began its investigation, Horton issued a letter to the client informing him for the first time of Horton's compensation for 2015 and 2016 and attempting to explain his fees. However, he failed to disclose the total amount that he paid himself in 2015 and 2016 and the amounts that he returned to his client. On or around February 12, 2016, the client signed a letter, prepared by Horton, authorizing Horton to liquidate and use monies for his client's care from a brokerage account. From February 2016 through December 2016, Horton made 16 transfers totaling more than $60,000 from the brokerage account to the client's savings account. Horton testified that he made the transfers when his client ran short of money and used the funds to pay for his client's expenses. However, the referee identified 3 instances in which Horton transferred funds from the client's brokerage account and used the funds for his own benefit. Herdiker testified that after review of Horton's accounts, he determined that Horton repeatedly and significantly overdrew his operating account due to insufficient funds during 2015 and 2016. Herdiker also reported that the audit of Horton's trust account revealed that he failed to follow the minimum required trust accounting procedures and that he failed to identify the client matter on all trust account checks, and failed to consistently identify reasons for transactions on the client ledgers. On May 1, 2017, the Florida Bar filed with the court a petition for emergency suspension alleging that Horton took improper loans from his clients, commingled trust funds in his operating account, and misused trust funds in violation of several rules regulating the Florida Bar. The court approved the bar's petition for emergency suspension and suspended Horton from the practice of law on May 3, 2017. Horton filed a motion to dissolve or modify order of emergency suspension. Following a hearing before a referee, the referee filed with the court his report recommending that the order of emergency suspension not be dissolved or modified.
The Florida Supreme Court took up the case on appeal. Horton argued that the referee's findings of fact and recommendation of guilt is not supported by the record.
Objection, Your Honor. That question is incompetent, irrelevant, and immaterial.
The bar sought review of the referee's recommended sanction and finding of remorse as a mitigating factor. Horton argued that there was not proof that his conduct was knowingly fraudulent or dishonest and that the referee therefore erred in recommending guilt.
Objected to on the grounds that the question calls for hearsay testimony, that it calls for a conclusion of the witness, that it is not the best evidence, and furthermore, it is incompetent, irrelevant, and immaterial.
The Florida Supreme Court disagreed, stating, "We find that the record in this case clearly supports a finding that Horton deliberately or knowingly engaged in dishonest and deceitful conduct." Next, the bar argued that the referee's finding of remorse as a mitigating factor is not supported by the record. The court agreed, stating that Horton testified at length about the harm to his reputation in the community and the effect these proceedings have had on his family. He accused the bar of prosecuting him as a trophy being hunted for the kill, so his head could be mounted on their wall, and compared the proceedings to facing a firing squad for a traffic violation. Further, Horton has continuously attempted to minimize his misconduct, asserting repeatedly that no client was harmed, and no money was missing. We find no evidence in the record to indicate that Horton has expressed remorse for his misconduct or otherwise accepted responsibility for his actions. The bar also challenged the referee's recommendation that Horton be suspended for 24 months. The court disapproved the suspension and instead imposed disbarment, stating in part, "The court has long held that the misuse of client funds is one of the most serious offenses a lawyer can commit. We will not be reluctant to disbar an attorney for this type of offense even where there is restitution." Here, Horton has demonstrated a pattern of misconduct involving multiple clients over a period of approximately 2 years. The referee found that he acted intentionally and that his pattern of activity during the relevant period of time was focused on his own interests. The referee also found that all of the affected clients were elderly and had no support from family or friends. In light of the seriousness of his misconduct, Respondent Dennis L. Horton is hereby disbarred.
With apologies to the late great Raymond Burr and his super lawyer character Perry Mason, I hope you enjoyed the presentation of the facts of this case. Now, the lessons from this case can be summed up into one. Be very careful who you put in charge of your money. Now, the reason the punishment for Mr. Horton was so severe is because anytime someone is put in a position of trust with another person, the trusting person is vulnerable. Mr. Horton was a fiduciary to his clients in his capacity as a lawyer, as an agent under a power of attorney, and as trustee for trusts he created for his clients. He owed them a duty of loyalty to serve them in their best interests. Now, this case is not a knock on lawyers, and the takeaway should not be to avoid working with them. In fact, it was the legal community, the Florida State Bar, who sought to police their own ranks and remove one of their members who was behaving badly. Attorneys are an integral part of the estate planning team. The ones that I work with are ethical, knowledgeable professionals. Still, there are many red flags that should be pointed out in this case. I should preface this by stating that the comments that follow are my opinions only and should not be taken as legal advice or acted on without the advice of your own legal counsel. First, whether it is ethically permitted or not, I do not believe that it is best practice for professionals to borrow from their clients, even if there are enforceable agreements. Most professional codes of ethics discourage or forbid such transactions between professionals and their clients. Second, too much authority concentrated in a single individual can be dangerous. In this case, Horton served as the drafting attorney for his client's legal documents, agreed to be named as agent under a power of attorney, and also served as trustee for the trust that he drafted for his clients. This is a recipe for disaster. Just as our government has a system of checks and balances, clients are better served by a team of independent professionals who are accountable to one another as well as to regulatory bodies. In this case, the clients would have been better served had they named an independent trustee and agent apart from Horton. Third, the fact patterns that emerge in this case, though only known through hindsight investigation, further substantiate the wisdom of avoiding power concentration. For example, in each of the three instances, the clients were elderly with no family support, and so it may seem reasonable or even generous that Horton offered to serve in so many roles. However, we also know from hindsight that Horton frequently overdrew his operating account or ran short of funds. For someone with financial problems of their own to have authority over the resources of vulnerable people is asking for trouble. According to the record, Horton had been an estate planning attorney in his community for years and had an upstanding reputation. Having access to easy money proved to be too great a temptation when he hit upon hard times, and in the absence of a team accountability, it ultimately led to losing his career and reputation. I hope that you learned something from this case and will take steps to prevent this from happening to you, your clients, or your loved ones. Until next time, I hope you enjoyed this episode of Wealth and Honor, the Case Files.